There we go. Okay, and there's Bruce. Well, good evening, everyone, and thank you for taking time to join us. It's here tonight to discuss a difficult topic. We are going to be talking about a group that we've worked closely with and we find to be of value, and we're here to talk about their bankruptcy and our involvement in that bankruptcy. We're not here to beat up on the Boy Scouts. We view it as a valuable program for many of the children in our churches, and they've provided very valuable youth leadership development across the country. But tonight we're going to be talking about the bankruptcy protection case that the Boy Scouts sought protection from their sexual abuse claims. That they started the case in February of 2020, and are using it to create a compensation fund for about 85,000 men who say they were molested as children by their scoutmasters. And it's alleged. It's who knows what really has happened. Chartered organizations or sponsors of troops have been brought into the bankruptcy. Many of us are either sponsoring a troop or a chartered organization. So tonight we have brought David Moore, the Synod attorney, in to talk with us about some recent correspondence that we've all received. It's gone to, not all of us have received it, many of us have received. It's gone to chartered organizations. And it's complex, and a lot of questions have come up, a lot of concerns about how we protect ourselves, why we're being brought into the bankruptcy, and what it could mean for our churches. David and I, in some instances, will try to answer questions. We'll keep track of questions, though, that we can't answer, and try to get answers for you. We would ask that if you have a question, that you use the chat feature and put your question in chat. If you wish to join the conversation and express your question verbally or offer additional information, we would ask that you use the raise your hand feature, and it'll raise a yellow hand into the box with your picture, and it would be helpful for us to be able to identify you that way. Should we miss it, just speak up and say, hey, I have something to say, let us know. So we will not spend a lot more time listening to me, and we'll move to David, who has quite a bit of information to share with us. So I'll move to David.
Okay, thank you, Jane. I appreciate the opportunity to do this, and I've had an opportunity to study this to enough of a degree that hopefully I'll have something to say here that may be of use to you. Well, let me do this. I'm going to share a PowerPoint here, which is relatively brief, but I hope will help to kind of organize some of my thoughts and to give you a little bit of a framework for what I want to talk about. I'm going to, I know there's a number of questions that have been raised that Jane has received that she's forwarded to me. And to the extent that this doesn't answer those questions, we can certainly talk about those as you see fit. My presentation will be relatively brief here. I need to begin because of my professional role here with a disclaimer because I represent the Synod here, which is really not directly involved in the issues with the Boy Scouts, and nor is Churchwide, the ELCA, because of the way the ELCA is organized. And because I'm not representing all of you as congregations, I need to say here that my intent here is to be a resource. So as the disclaimer indicates here, the information I'm providing is not intended to constitute legal advice. It is informational. So I'm not representing you. And to the extent you really need advice as to what to do in an individual situation, you need to consult your own attorney. Having said that, as I say, I have looked at this. I guess I can say that my qualifications to be talking to you about this are that I have a law degree. I have some background in bankruptcy law, and I'm an Eagle Scout. So put those together and see what value those things provide to you here. But I want to make it clear at the outset that I'm going to talk about what are really two separate issues here. And what's happened is I think the second issue is maybe surfaced questions relating to the first issue. I want to talk first about the effect of and what it means to be a chartered organization under the current structure of the Boy Scouts. And then I will talk about the bankruptcy proceedings in particular. Actually, I think, and I think that the best way, well, I had a couple of slides here. I'm gonna stop sharing this and instead share with you the BSA, Boy Scouts of America charter document, which I believe is pretty much universally in place. If you are part of a congregation that has a Boy Scout troop, you're probably operating under this format of the charter agreement. And if you take nothing else out of at least this part of the presentation, I take this, read it, because what you I think may find is that the relationship that your congregation has with the Boy Scouts may not be as you have traditionally thought of it. Certainly, even as I have traditionally thought about the way Boy Scout troops work. I'm going to actually, well, let me use the spotlight feature here. At the outset, this part says it uses some interesting wording that I assume would be of some significance. I'll read it. The purpose of the Boy Scouts of America program is to prepare young people to make ethical and moral choices over their lifetimes by instilling in them the values and principles taught in the Scout Oath and the Scout Law. And it goes on to say that the chartered organization is a duly constituted organization that serves youth. Now, the chartered organization, that's you. That's the congregation, desires to use the program of the BSA to further its mission, respecting the youth it supports. The local council provides the support and service necessary to help the chartered organization succeed in its use of scouting. So the theory is not that you're providing a place for the Boy Scouts to meet. You are using the scouting program as a program of your congregation. And I guess the way I've said it, it's essentially the same as your confirmation program. It is your program and you're using the Scouts to conduct your mission. So, and here in this portion, you'll note that the chartered organization is agreeing to use scouting to further its aims and values. And it must utilize the program to accomplish specific objectives related to one or more of the following. And then there's 5 bullet pointed areas there. Now, this is the entire charter document. There is also a back page to the form that I've seen. Oh, I see that carries over the my little artful circles there. But there are some other provisions that are of some comfort in terms of how it works, including the provision here that include, sorry, excuse my lack of proficiency, but it does include a provision that says that the local council agrees to, among other things, conduct criminal background checks on adult leaders approved by the chartered organization. That does not, however, relieve the congregation itself from the responsibility, the same responsibility that exists with regard to volunteers, particularly volunteers that work with youth. So the point again, I think this is, you are undertaking a responsibility to use the scouting program for your mission, not facilitate the mission of the Boy Scouts of America. And that's important to understand. So that being the case, one of the questions that that Jane has gotten, that has been passed on to me, or among the questions that have been passed on to me are questions with regard to tax ID numbers. The Boy Scout troop doesn't have a separate tax ID number. It's working under yours, and it is because you are the chartering organization. The ultimate question, of course, has been, should we continue to do this? Do we want to continue to sign on with the Boy Scouts? And I'll say about 2 things about that. This document, while it traditionally, as I understand it, is signed annually, contains no timing provision. So the decision to either join or to terminate this agreement or renew it is not something that happens on a particular date. It is a continuing agreement. It does not, by its terms, require that it be re-signed annually. But as I understand it, the Boy Scout Council, Glacier's Edge, does ask for this to be re-signed annually. If the question is one of, again, should we continue to do this? My answer has been, do you want this to be a mission of your congregation, and are you willing to treat it as such? And beyond that, I think that is a question that each congregation can and should answer for itself, eyes wide open, again, reading what the charter agreement says. So again, looking at my, sorry. I include that this is the words from the charter that I just referred to. I won't read them again, but the very specific provisions as to what you're doing when you have a Boy Scout troop operating. So I'm going to, and we can address questions as you, whenever you want to here, but I'm going to move on and talk a little bit about the bankruptcy with the second topic and what the effect of the pending bankruptcy proceedings are. The bankruptcy that's been filed under Chapter 11 of the United States Bankruptcy Code is a bankruptcy. It is a Chapter 11 proceeding initiated on behalf of the Boy Scouts of America, and actually one individual counsel, Delaware BSA. It's actually two bankruptcy cases being jointly administered. It does not, the local councils are not in bankruptcy, and of course, individual bankruptcy or individual Boy Scout troops are not. Of course, your congregations are not part of that bankruptcy. But what you need to understand, and this is the way bankruptcy law works, and in this particular case works, is that the pending BSA, the Boy Scouts bankruptcy, may affect, will affect any future claims that might be made against an individual chartering organization. So in other words, if a claim is made against a congregation that involves abuse, that what happens in this bankruptcy can and will have an effect on how that claim will be handled. In order to understand how this works, you need to understand, and those of you who've looked closely at what you may have gotten from the bankruptcy courts, is that basically it creates three categories of claims. That is, claims of abuse that occurred before January 1st of 1976, then claims of abuse that occurred since then and until February 18, 2020. The significance of that date, that was the date of the filing of the bankruptcy. And then claims that occur after that date. And the significance of that January 1st, 1976 date is that at least the Boy Scouts claim that, and I don't necessarily have any reason to doubt this, but and lawyers who know more about this than I do have said that that there is insurance coverage for chartering organizations, for congregations, for any claims that occurred after that date, that the Boy Scouts of America had coverage that would cover chartering organizations. Claims before that date, before January 1st, 1976, individual Boy Scout councils may have coverage, and coverage may exist, but the Boy Scouts of America are indicating that they did not obtain coverage for chartering organizations before that date. So I'm giving you these dates just to understand those three classifications. So what does that mean in this pending bankruptcy proceeding? So the label I put up here, the pending plan. There is a plan, and this is the way it works in bankruptcy and in Chapter 11. Somebody, usually the debtors, by negotiating with a committee of creditors, comes up with a plan, and that then goes before the bankruptcy court, and a couple of things happen. Number one, the court has to kind of say, okay, this looks like a plan that we can put before the persons who are creditors in this bankruptcy, and we're going to have a vote on this, and the vote depends on the size of the claim, and it depends on the number of creditors. But then ultimately, once the voting process has occurred, it comes before the bankruptcy court in a confirmation hearing, and the court decides whether it will approve that plan. And once the plan is approved, that plan then, in this case, will have an effect not only on those people who have made claims against the Boy Scouts of America, but also in this case, on chartering organizations and the protections that will be available to the congregations, to the chartering organizations. And this is a creative and long plan. Those of you who received this mailing, which I think is 37 pages long, that doesn't actually include the plan. You'll note that there are links in which you can, or websites where you can acquire a copy of the plan, but it does explain, it does include a summary of the plan. And what the plan involves in this case is a system whereby the insurance company that has provided coverage, I believe it's Hartford, it is going to, they're going to contribute a pool of money to the plan, to a settlement fund. And the Boy Scouts of America are going to contribute additional money to that fund over and above what the insurance provides. And local Boy Scout councils will contribute money to that. And chartering organizations may contribute to it. And I think that the question that has arisen for those of you who've looked at this is one of, should we be voluntarily contributing to this settlement fund, which is a large amount of money, I believe, north of $1 billion, or ultimately will be. As indicated here, the bankruptcy court has the power to basically set the rules if this plan is approved and confirmed by the bankruptcy court, and it will affect how future claims are handled. But it's just a plan right now, and it will not take effect unless and until the court approves it after voting by the holders of claims and the court's review at a hearing that's scheduled for January 24th of 2022. So what do you do in the meantime? What, if anything, should you do? The plan contemplates that for chartering organizations, for congregations, they have three options. And the first option, I'll state at the outset, it is a default option. So if you do nothing, if you, from this day forward, you're going to fall under option one. And the effect of that is you're not contributing to the settlement fund. The chartering organization will remain liable for any pre-1976 abuse claims. Those abuse claims that are the result of acts that occurred after January 1st, 1976 will be covered, will be included within that settlement trust. They will be paid or they will be handled through that settlement trust. Well, again, I can't advise an individual congregation as to what to do. I expect that most congregations that I'm aware of in this synod are going to be inclined to choose option one. And the reason is that they're not aware of, don't suspect that there are potential abuse claims out there. They recognize that there is a possibility, but they are reluctant to go to choose option two. And the reason is that option two requires putting money into the settlement trust. Option two applies for any chartering organizations that choose to make what's called a substantial monetary contribution in the explanatory materials to the settlement trust. Well, how much is that? Well, you don't know, because the materials provide that you can who to contact, and you can negotiate an appropriate amount with who's ever in charge of those negotiations, and you can decide what would be an adequate amount by discussing that with them. And if you successfully do that, then what will happen is that all claims of abuse, that is, including those that are pre-1976, will be covered under the settlement trust and paid and handled exclusively through that settlement trust. So if there's an attractiveness to that option is knowing that it will cover any claim, while if you choose the default option, that is, if you do nothing, and you then only those claims from January 1st, 1976 will be covered by the settlement trust. That means that doesn't mean you aren't able to defend the pre-1976 abuse claims. It just means that you don't get the benefit of the settlement trust to pay those claims. The third option that's provided is an opt-out, which is to say, we're not going to do the settlement trust. We're going to handle our own issues. We're going to retain whatever rights we had before the bankruptcy to bring in insurance companies. But we're going to have to, we're going to be on our own. We are not going to take the benefit of having the settlement trust, and we are going to deal with those claims as we would have if there were no bankruptcy. Now, there are some deadlines that we've been asked about, and I want to be clear on what those are. This December 4th, I guess I'll do this in reverse order. If a congregation has already filed a claim, and there was some discussion about that a few months ago about whether congregations that don't know about particular abuse claims want to file what in essence would have been a conditional claim if we get a claim made against us by a victim of abuse, then we want a say in this process. I'm not aware of any congregation in the Synod, I don't necessarily know, that actually went through the process of filing a claim. The only significance of that December 14th deadline is if you did file a claim, you have until December 14 to vote on your choice as to whether to adopt the plan that I just very superficially described, and which is described at more length in the materials that were sent out by the bankruptcy court. The January 7th, 2022 deadline, if you are going to choose anything other than option 1, then you have to file the appropriate document with the bankruptcy court by that date. Again, option 1 is a default. If you do nothing, then neither of these, and you have not filed a claim, then neither of these dates are problematic for you. So that's in a nutshell what we're dealing with, both from the standpoint of the organization, how the chartered organization concept works, and the bankruptcy proceeding. Jane, how do you want to, I could work off the bullet points of the various questions that you've sent to me, or we can just proceed and take questions here, however you want to do this.
We can work off the bullet, but there are some new ones that came up. And let me point out some of the documents that we've referenced that some people may or may not have are in the chat. And Robin, they can download those. Can they be downloaded?
Yeah, you can download it right from the chat. Also, I did send them in an email prior to the.
Okay, great. So those are available to you. I also note that during the discussion that there was an updated version of the charter organization. I just read it. It's not significantly different, but it is updated. And I sent
Okay.
that to you, Robin, and maybe you can put that in the chat room as well.
I'll do that.
Couple of additional points I wanted to add. I spoke with Ron Timmons, who is the executive director of Glacier's Edge. And he noted that some people think they don't have a charter, but maybe operating off of a charter agreement that was signed eons ago. And, you know, it just has continued and folks think they don't have a new one, but they do. He also noted, and so does the document out of the bankruptcy court, that is if you charter, sponsor, or allow in other ways support troop activity, you're probably treated the same. So it's important to note that it's not just if you've signed this agreement that some of this stuff applies to you. I was surprised to learn that myself. So why don't we take some of the questions that came up? There are two here. And
Off
then
the chat.
you have a list. Can you see those? Is the chartered organization only liable for cases that occurred with leaders of the unit chartered through that particular church?
Right, and if I understand that correctly, yes. I mean, if the chartered organization is not going to be liable for other claims that are made within that particular Boy Scout council or another congregation, another organization. Your congregation is a separately incorporated entity, and you are not, absent some extraordinary facts, going to be liable for claims that were not part of what happened in a troop for which you were the chartering organization.
One of
Go
the
ahead.
other questions attached to that is, why would the Church of Latter-day Saints, the Mormons, the Methodists, and the Southern Baptists put large sums of money into the compensation fund?
Right, and the answer to that question is that those denominations are organized very differently from the ELCA. As you know, we have three different levels of incorporated entities: the churchwide, the ELCA, the Synod itself is separately incorporated, and each congregation is separately incorporated and owns its own property in the ELCA. That is not the case in the Methodist denomination. The property is owned by the local district, and I believe the Mormons operate the same way. So again, the good news is under the ELCA, we're not all in this together to the extent that any claim made against anything other than your own congregation is the responsibility of anyone other than the congregation.
So you've got the list there that I sent you, David, but
Yep.
you.
Yeah, I don't have that posted, but I'll just go through that. That's okay. I've got actually about a dozen, well, maybe 15 questions here that Jane had forwarded to me. And the first, and some of these I'll tell you at the outset, I'm not going to be able to answer because it's going to be, well, it depends. But the first question, how do we discern if we should sign another charter? And my answer to that one is, are you prepared to undertake the responsibility that the charter reflects? And if that's consistent, something you want to do as part of the mission of your congregation, again, eyes wide open, then that's a choice that is an appropriate choice for you. That would be my answer, the best I can answer that question for you. I just yeah, again, rule number one, read the document. So the second question is, and I hope that how can a charter have liability? I mean, if you have a scoutmaster who engaged in abuse in way back in the 70s or whenever it was, and that abuse claim is made in the future, there is a potential for liability. If this plan is approved, again, and you don't opt out, anything for a claim that would have of abuse that would have occurred after January 1st, 1976, you will have the recourse provided in the settlement fund to deal with that claim. But we're generally talking here about abuse claims made within by leaders of Boy Scout troops in chartering organizations, including congregations.
Can I add to that, David, that one of the things Tom Cuniff, I always get tongue-tied there, I'm sorry, told the vice presidents of the synods is to tell your congregations that they should try to find their, if there's concern, they should find their insurance records as far back as they had troops.
Right.
All of us gasped and went, you know, finding your insurance records back 80 years is just not something, you know, that you're going to be able to do. But he did encourage us to suggest that have as many of them, particularly pre-1976, as you can. Now, the hope would be that you had the same insurance carrier for a very long time. But I do encourage people to look for those records.
Right. Yeah. And for those of you unaware, Tom Cuniff is the general counsel for the ELCA. The next question I have is, how do we protect our assets from the bankruptcy and the compensation fund? Your assets, your congregational assets are your congregation's assets, and there is no way trying to move those to another organization would not be effective in the event of a claim. The only thing I'll say that's been said before, you need to be probably in every case I've run into, congregations are incorporated under Wisconsin law, whether or not they've filed a formal articles of incorporation with the state under Wisconsin law. Typically, your congregations back in the beginning would have filed the appropriate document with the county register of deeds that gives you the protection of any other non-stock nonprofit corporation. So I'm just going to move through here. Next question, why didn't all charter organizations get the options document? I don't know the answer to that. I'm not surprised by that, given the scope of this bankruptcy. The bankruptcy court would have sent these out based on a mailing list that would have been put together by the various parties involved, but it also doesn't matter. If you didn't get it, we can forward you a copy of what was sent out to other congregations. Whether or not you got it will not affect your ability to take the action or inaction that I've described. If you didn't get the document, just ask. We can Jane or who's going to get them.
It's in the chat. You can download it now.
Oh, it is in the chat. I'm sorry.
Yeah.
It is there. Okay, so it's there. And
It
that
is the
actually,
email.
what this is the 37-page explanatory document. It's actually two documents. There's a summary, and then there's the official notice from the bankruptcy court. But it includes, if you want to actually look up the entire plan and supplementary materials, it has the website or the links to do that. So it doesn't, the fact that you didn't get it really doesn't change anything. The sub bullet point to that one is what's the best option to select? And I'm not going to tell you that. I'm going to tell you that that depends on your individual congregation's preferences, but I would expect, as I said, that most congregations are going to elect option one or the default option, simply because for two reasons. One is it provides some level of protection. Number two, it doesn't involve any financial contribution. And I think in many cases that will be a rational choice under the circumstances. The question again, I have answered it. What if we do not respond? You're going to be covered by option one. So, and other related question, why would you submit a contribution to the compensation fund? I guess if you wanted to be absolutely certain that you were covered under the settlement fund and it was financially realistic. And in particular, if you think there might be a claim like that out there, that there's been stories around, that might be a good reason to consider option two. And the question, has it really gone over $1 billion? Yeah, I think so, but I'm not sure. It's a lot of money. And it will be, I mean, any claims made are going to be paid out of that fund under the terms if the bankruptcy court approves the plan. Next question I have, if we do not know of any abuse in our troops, should we just ignore this? You should not ignore the question of whether you want to operate under the charter agreement that that your congregation has. If you do not know of any abuse, do you want to ignore the bankruptcy proceedings? Again, the effect would be that you've chosen option one. I think that is a rational choice, depending on the individual congregation, as I've said. Next question. We know that there was abuse in Glacier's Edge Council. Will all charter organizations be held accountable and required to participate in the compensation fund? Again, no. Charter organizations are not going to be held accountable for actions or incidents of abuse that occurred in other chartering organizations, at least in ELCA, talking about ELCA congregations. And are you required to participate in the compensation fund? Again, the answer is no, as long as you understand the effect of the default provision. The next question I have is that, an interesting one. Can we simply offer the use of space? And if so, what is the best way to do that? And yeah, I mean, the question is whether the Boy Scouts are willing to operate under that arrangement. We do have, I see in the material, we have the building use agreement that I believe came off the ELCA website.
Yeah.
Basically, how to deal with any building use situation where you're leasing space to an outside organization. So from the ELCA's point of view, from a congregation's point of view, yeah, if you want to provide space, whether in return for payment or without cost, you can choose to do that. The problem is whether the Boy Scouts are prepared to operate under that arrangement. I just learned yesterday, my brother is a scoutmaster in a Methodist congregation that is a chartering organization. And again, the Methodists are saying, no, we're out. We're not going to do this. They are terminating the charter, and and the church has said, it's fine, you can come here and you can use our space, but you're going to have to find somebody else to be a chartering organization. So they're looking and trying to figure out how to do that. Speaking again from my brother's perspective as the scoutmaster. The next question, how do charter organizations fit into the Boy Scout structure? I believe I've explained that as best I can. It's under the terms of the contract. The next question, should the ELCA be part of an organization, a BSA, that allowed for so much sexual abuse? That's a judgment call. And I'm no more qualified than anyone else to raise that issue. I said at the outset, I was part of scouting. It was an important part of my life. I observed no sexual abuse whatsoever. But that was pre-1976. I don't know what the experience has been. All organizations, including the ELCA, have recognized the effect of and the prevalence of sexual abuse where we didn't expect to find it. So I'll let you make that call. I think I've explained the difference between 1976 claims and post-1976 claims. If there's any follow-up on that, I'd be happy to respond to that. I believe I've explained the effect of the response dates. If you have any follow-up to that, be happy to respond to that. And then, can additional lawsuits be brought against individual churches? Yes, suits might be brought, but how they will be handled will depend on the congregation's response or choice not to respond or to opt out of the bankruptcy proceedings. And certainly if a claim is made for abuse that occurred prior to January 1, 1976, and you have chosen the default provision, that would be handled just as it would have been before the bankruptcy. I will say one thing I didn't say, I may not have made this clear. If it's a claim that occurred after February 18, 2020, you can get sued for anything that's happened since that. And of course, you can be sued for anything that happens from this point forward. Because if you enter into a charter organization agreement, such as I've described, you are undertaking that responsibility. And unless the arrangement is different, that's part of the deal, just as it is with your confirmation or any youth program you have within your congregation. There is the potential for a lawsuit. And I assume everybody has insurance now.
David, would it be prudent to review your church's insurance coverage to make sure that you have enough provision or coverage if you're going to have youth programming in your church?
Yeah, sure. I mean, I think that's a good idea. Make sure you understand what coverage you have, and what your insurance company is going to tell you, of course, is, well, and do you have, in terms of best practices, are you doing these things that you need to do in this day and age with any, in particular with any youth-related program. So.
Was that the list, David?
That I've covered the list. I'm just, yeah. Any other questions?
Yeah. Let's open it up. Do people have questions? There's one from David Froming. Do I say that wrong? I apologize. Has anyone read the November 19th letter from BSA? It states that we will be released from any post 1975 abuse claims.
I have not seen that letter.
Okay, this is a letter from Blackhawk Area Council to me. A voting plans communication, and it comes from the CEO, Cedric Robinson, who I spoke with by phone. And I said, you know, can you make that claim? And that was going to be my question tonight in this letter. And I didn't realize that they carry insurance. They do. But can they make such a claim? Is there validity in this statement? That's my question.
Yeah, I think in general, my understanding of the way the bankruptcy plan will work is, well, actually, this is two questions. Number one, is there coverage? And the Boy Scouts of America claims there is coverage. I have not personally examined that. I've communicated with responsible lawyers within the ELCA Attorneys Association who are actively involved in this litigation, that they believe, yes, there is insurance coverage. And the reason that Hartford Insurance Company is contributing to the settlement fund is that they acknowledge that there is coverage to a point. So again, I haven't personally, I put it this way, I can't say that that's untrue, and I have not heard from anyone who says that it's not true. The second part is that if this plan is approved, as I understand it, it will have the effect of, that the settlement fund will cover and will encompass any future claims within the boundaries of that settlement fund. So if this plan is approved, the answer to that should moot the question of whether there is post 1176 coverage. That will. So I think that's the best way I can answer that.
Other questions?
Oh, I know what the qualifier is. The reason I was hemming and hawing there. If you choose option 3, that is, if you opt out, then you're not affected by the bankruptcy plan, and you can Hartford will not be responsible. Wait, I'm getting this. I want to make sure I get this correct after reviewing this. But if you opt out, the question of insurance coverage is not answered by the confirmation of the bankruptcy plan. You're back to square one. Is there coverage? You would still have a claim against Hartford, but it wouldn't be under the auspices of the bankruptcy settlement fund.
There's another comment in chat from Brad Culbertson. Says the BSA youth protection training is there for every church to use. That's part of the charter agreement, and that's accurate. The flip side of that, I'm wondering, is do most of your churches also have policies for working with youth programs and things like Too Deep Leadership, and do you share that with the Boy Scouts if you're going to continue a relationship and let them use your space and building?
I'm sorry, when you mean let them use the protection protocol?
No, I'm just saying we all have policies Christ
Right.
Lutheran and Forest have our own policies. And do you also share those with the Boy Scouts so that they effectively also adopt our policies?
Yeah, I mean,
I think that's important.
yeah.
Any other questions?
I see. Will we know if the bankruptcy program will be approved before the December 14 deadline? Again, that the December 14 deadline is of no consequence, and unless you've already filed a claim in the bankruptcy proceedings, and the deadline for that occurred some time ago, a couple of months ago, as I recall. The only deadline you need to worry about is January 7th, if you are going to choose option 2 or option 3. But the ultimate approval by the bankruptcy court will not occur until at least January 24 of 2022. And the fact is, it's not unusual for bankruptcy courts to continue confirmation hearings because they're not ready to, for one reason or another, they're just not prepared to rule. But it's not going to occur before January 24.
Okay. All right.
Mhm.
Any other questions? Does anyone know whether there are any specific law firms that are representing churches in Wisconsin on this issue? David and I had this conversation a while ago. I'm not sure that we do.
I do not know of any law firm in Wisconsin that's involved in beyond beyond advising an individual congregation on the things we've been talking about this evening. There are, again, firms outside the state of Wisconsin, including some lawyers who are part of the ELCA Attorneys Association, who are actively involved in representing a number of either congregations considering this or are actually involved in particular claims that have been made, that is, claims by particular victims. Oh, yeah, sorry. I guess that I was looking at another comment there.
So the only other firm that I mean, Rick Santee, who David, from the Moravian Church, his firm is representing the Moravians in this issue, and I don't know if they would take on any other churches wanting to look at it.
Right, he's in Pennsylvania, right?
Yep.
Yeah.
Yep.
Yeah, the friend, I'm not recalling the ELCA attorney that I know of, I believe is out of Texas, the one in particular, and I'm not recalling the name, but they're on the listserv that I'm part of, and I can certainly get those. Okay. And David Frumming's comment that the CEO told him that the BSA is now conducting youth protection training every 2 years. Yeah, I'm sure that the plan is to have those programs in place for the future.
Okay. So as we go forward with this, individual churches have lots of decisions to make. What is your commitment to the Boy Scout troop? What kind of support and programming? Are you going to go with a charter agreement? Are you going to go with a, building use? How are you going to make those decisions? Unfortunately, that's something we have to all make individually as congregations and think through. It's hard to evaluate what your risk is in this situation. And I know that's a big question that people have. How do we protect ourselves? But it's hard. We can check in with one another and talk about it and ask some certain questions, but you're going to have, I think, to make these decisions as we go into the new year. And I hope the Boy Scouts, this is my personal commentary, will start to look at their arrangement with our churches and maybe think through a different kind of process so that, maybe we don't have to sign those charter agreements and maybe we have a different kind of relationship, but that's, I'm sure, to come down the road. Anything else that would be useful tonight? Well, we have David, who was generous with his time to prepare for tonight and to be with us. I want to thank him. I find him to be calm and to keep me calm when I get worked up and angry and animated over some of this stuff. But I really appreciate his leadership and in being available to us. So thank you.
My pleasure.
All right, it's the appointed hour. We're right on time. It's 8:01. And it's an evening time. So I want to thank everyone for participating. And Robin, thank you for staying with us and coming back to work in the evening. I appreciate that. And we will be available if you have questions and see if we can get answers for you. So thank you.
Good night.
Good night.